Yes, well, we move on to your appeal now, I think. Cross appeal, perhaps it is.
Yes, this is our cross appeal, and it concerns a discrete point concerning persons who fell within the class but who died before the collective proceedings were issued on the 20th of February 2020. And
is that right?
I hope so.
Is it whether a person who died is in the class at all? Or you,
Lord, yes, that is also an issue. That's one of the points.
Yeah.
Yes, perhaps I can elaborate on it, and then we can see whether I've misstated it in terms of my first sentence. I hope not. But the starting point in our submission is that it was always intended that the collective proceedings would encompass claims that vest in the estates of deceased persons. And in that respect, we say that these proceedings are in contrast with the circumstances in Merrick's, where there was an express exclusion of deceased persons from the class, and it was made clear both in the quantum figures and in communications to the class that deceased persons were to be excluded. In these proceedings, we say that the claims of deceased persons fell within the class definition, first of all, and that's if we look at Supplemental Bundle tab 1 at page 14. This is the class definition in the claim form. And it encompasses all persons who during the period 18th of October 2006 to 6th of September 2015 either purchased or financed in the United Kingdom a new vehicle or a new lease vehicle other than a new vehicle or new lease vehicle produced by an excluded brand. Now, at the time that the person who is now deceased purchased or financed a vehicle, they were a living person and they were within the class. If they have since died, then in our submission that claim now vests in their estate, but that claim was always within the class definition. Now, the respondents to the cross appeal have cited an authority for the proposition that the ordinary and natural meaning of the word person is a living person in the particular context of the statute that that case was concerned with. And of course, context is everything in terms of issues of construction. Here in our submission, the focal point of this class definition is the act of purchasing or financing of a vehicle. And at the time when that act was done, the person was indeed a living person. And it is self-evident that such a person may subsequently pass away, but in our submission it's the ordinary and natural meaning of the class definition in the context of this claim that the claim is tied to the act of purchasing or financing the vehicle, and so it is included in the class. It's also said against us that persons must be construed as living persons because it's well established that a deceased person can't be a party to proceedings. And so it said, well, we must read persons in this context as deceased persons. But it is equally well established that there are recognised mechanisms for representing the estates of deceased persons and for pursuing claims on their behalf. So in our submission, there's no basis to read the class definition presumptively to exclude those claims. So we say the first point that indicates that these persons were always intended, or these claims were always intended to be encompassed within the scope of the class, is the class definition itself. We also rely on the estimates given by the class representative for the size of the class, which include deceased persons. And if it looks in Supplemental Bundle tab 5 at page 211,
sorry, reference again, sorry.
I'm sorry, it's Supplemental Bundle tab 5, page 211. This is the class representative's litigation plan. And paragraph 15 is under the heading Procedure for Governance and Consultation, and it's commenting on the extent to which it's possible to determine the number of members of the proposed class with precision. And it says, as set out in Appendix 4.3 of the VDO report, approximately 22.0 million new vehicles were registered in the UK during the relevant period, of which approximately 4.2 million were excluded brands. The remaining 17.8 million new vehicles were purchased or financed by potential members of the proposed class. So the point we make is that the estimates given by the class representative for the size of the class did not include any reductions for persons who had subsequently died. They were simply based on the number of vehicles registered in the UK during the relevant period. It's also the case that the estimates given by the class representative as to the quantum of the claim were based on the numbers of vehicles registered with the DVLA, with no reductions for deceased persons. The court can see that supplemental bundle, tab 7, page 333. This is Mr. Robinson's report, paragraph 8.13 under the heading Preliminary Estimate of Loss. And he says, in relation to the number of new vehicles registered in the UK during the relevant period, I've used data from the SFT, which is the Society of Motor Manufacturers and Traders. And the point here is that he hasn't made reductions from those figures for the purposes of his quantum calculations to reflect deceased persons. And it's also right to say that the communications with the class, including the notice of proceedings that was approved by the tribunal, did not expressly exclude deceased persons. So our starting point in our submission is that it was always intended that the claims that vest in the estates of deceased persons should fall within the class that was sought to be certified. As the court is aware, the limitation period in respect of the claims expired shortly after proceedings were issued. And the judgment deals with this question, Core Bundle, tab 11, page 193. Paragraph 171, under the heading Deceased Persons, the tribunal rightly found that the description of the class would extend to any person who acquired a new vehicle or new leased vehicle during the relevant period, irrespective of whether that person has died or if it was a corporate entity has been dissolved. We say that it's correct to have understood the description of the class in those terms.
Just out of interest, if you've got a dissolved corporate entity, where's the damages going to go?
Well, my lord, in fact, we don't need to worry about that because we've indicated that the class definition will be amended to exclude companies that have since been dissolved. That's the sentence halfway down 171. Yeah. So we are only here concerned with deceased persons rather than corporate entities. Paragraph 173 refers to Merrick's remittal, and it says, as explained there, 48 to 49, proceedings commenced in the name of or on behalf of deceased persons are a nullity. We do not seek to challenge that proposition. The court looks at paragraphs 175 to 176. What we did do is we sought to argue below that the class definition could be construed so as to encompass claims that vest in the estates of deceased persons. And that argument was rejected by the tribunal. And the tribunal held that the proposed amendment to the class definition that we were seeking to include amounted to seeking to add new class members. And again, we do not challenge that conclusion. The court looks at paragraph 180.
Sorry, the conclusion you're not challenging is what?
Is the rejection of our argument that the class definition could be construed so as to encompass claims that vest in the estates of deceased persons. We sought to address this purely on a question of construction.
Right. Where have we got to here? You say it was always intended to include these claims, but in fact, as a matter of construction, it doesn't.
The CAT has found that as a matter of construction it doesn't. We have not sought to challenge the construction, and we have not sought to challenge that the consequence of that is that the effect of seeking to amend the class definition is to seek to add new class members. We accept that that is correct.
So those claims are not in fact within the class. And this is all about adding new members.
The relevant rules are set out at paragraph 180.
Do we have the amendment?
We do. I think it's probably in the claim form, which is in tab 1. It may be that actually the claim form as included has not included the amendment because it wasn't permitted.
You're actually appealing the refusal to allow you to amend, so we ought to have the amendment there.
Your Lordship makes a fair point. In fact, the wording of the amendment isn't really determinative, but I'm sure we can obtain a copy of it in the bundle.
I think it's core bundle, page 82. It's your response.
I'm grateful. Grateful to Mr. Pitchenham for drawing attention to my respondent's notice, which is behind tab 6 in the core bundle. And
page 85.
Page 85 is the order sought, yes. Seeks the variation to exclude or to take out the exclusion for persons Yes, this is the current version. That's not actually amendment, I don't think.
Yeah, the one that's in the bundle at 14 to 16, it was obviously a it's two drafts back, I think, because this deletes an F, which we don't have, do we? Or maybe we do. Hang on.
No, we don't. Page 16 is excluded persons. We haven't got an E either.
Oh, is that in the order, do you think?
The CPO order is at tab 12. So the order as made contains an exclusion under the excluded persons at F.
Oh, I see. Page 203 in the core bundle. So E deals with dissolved companies. That's why we haven't got the E.
Yeah.
And then F is excluding people who died before the 20th of February 2020. And that, I assume, is when the proceedings were issued.
My lord, that's right. Yeah.
Right.
My lord, we were looking at the rules which are in the judgment at paragraph 180.
Yeah.
It's Rule 38 provides the tribunal may grant permission to remove adults from the proceedings. Subparagraph 6 then concerns after the expiry of a relevant period of limitation. The tribunal may add or substitute a party only if, subparagraph B, this additional substitution is necessary. Subparagraph 7 then talks about circumstances where it's necessary, and it says the additional substitution of a new party, as the case may be, is necessary for the purpose of paragraph 6b only if the tribunal is satisfied that. And then there are 3 options. The one to which our cross-appeal relates is option B. The claim cannot properly be carried on by or against the original party unless the new party is added or substituted as claimant or defendant. Now, the reasoning in the tribunal's judgment is at paragraph 181. And they say, since the limitation period has expired, Rule 38.6 must be satisfied. What is necessary is exhaustively defined by Rule 38.7. In our view, the applicant has not demonstrated that any of the provisions of that rule apply. It was not suggested that there was a mistake in the connected proceedings claim form within subparagraph A. Both of subparagraphs B and C require there to be an original party, but where a claim is brought on behalf of a person who is already dead, there is no such original party because claims brought on behalf of deceased persons are a nullity. We challenge that finding insofar as it concludes that Rule 38.7b cannot apply because it requires there to be an original party, and there's no such original party because claims brought on behalf of deceased persons are a nullity. So we challenge that reasoning insofar as it applies to Rule 38.7b.
And your challenge is because there was an original party, or that an original party is not necessary?
Our challenge is because it is supported by reference to a particular authority, AIG Europe, which I will show the court,
Yeah.
which tells us that the circumstances of Rule subparagraph B are capable of encompassing claims which are a nullity. And to be fair to the tribunal, we did not cite this authority below. What we did do is make a submission that the circumstances of the present case should lead to the conclusion that one or other of the provisions of 38.7 should be capable of encompassing the present scenario. But we do say that if we are right on the basis of this case, that claims which are a nullity can fall within this rule, and there's been an error of law in rejecting the application of the rule in relation to 38.7b.
Yeah.
So the case in question is Authorities Bundle tab 16. It's volume 1 of the Authorities Bundle. And it's AIG Europe Limited and McCormick Roofing Limited. And this is an application made by AIG Europe SA to be substituted as claimant in these proceedings. AIG Europe SA was the assignee of the cause of action of AIG Europe Limited, which had been named in the claim form, and AIG Europe Limited had ceased to exist. So in those circumstances, AIG Europe SA was applying to be substituted. If we look at paragraph 24, this is setting out the applicable CPR rules. And the terms of CPR rule 19.53 are in the same terms as CAT rule 38.7b. And they fall to be interpreted in the same way by reference to the guidance that's given in the CAT's Guide to Proceedings. We look at 28. We can see this is court consideration of Rule 19.53b, and it requires the court to be satisfied that the claim cannot properly be carried on by or against the original party unless the new party is added or substituted as the claimant or defendant. The court records in 29 that it's been referred to relevant authority, and it addresses in turn 3 different cases. The first is Parkinson Engineering Services PLC and Swan, paragraphs 30 to 31. And that was a claim where the defendants were administrators of a company, and there had been an order releasing them from liability. And the liquidator caused the company to commence proceedings for negligence against the administrators, to which it was pleaded that the claim was barred by reason of the release of liability. And so the liquidator then applied to substitute himself as the claimant. And we can see the Court of Appeal's determination of that application at 31. And this is Lord Justice Lloyd saying, on the question of jurisdiction, whether it's open to the court to permit the substitution, it seems to me that this is a case in which the substitution is necessary in terms of section 35(5)(b) as well as CPR rule 19.53b. The original action asserting the company's claim against the former administrators cannot be determined without the substitution of the liquidator, whereas if brought by the liquidator under section 212 it can. Without that substitution it could only and would be bound to be determined in favour of the defendants because of the section 20 defence. That's the order excluding liability. The claim would be struck out because of that defence and it could not be decided on its merits either way as the proceedings stand. In terms of the rule, it cannot properly be carried on by the original party, the company, whereas it can be maintained and carried on if the liquidator is substituted. No more than minimal change is necessary to the statement of case. Substitution of references to the liquidator as claimant and references to the company in the third rather than the first party, so to speak, together with consequential changes as regards the relief sought. It is the same claim in every respect, despite the fact that it is asserted by the liquidator on behalf of the company rather than in the name of the company itself. So that is the first authority that the court cites, and the reasoning is essentially that the claim cannot be determined without substitution, but if brought by the liquidator it can, and the court's placing emphasis on the fact that no more than minimal change is necessary to the statement of case. It's the same claim in every respect. The second case that the court considers at 32 to 35...
That's not a case where the original claim was a nullity. It's a claim where it was liable to be defeated.
My lord, that's absolutely right. And we come, I think it's 41 in this, in this judgment, to the court's consideration of the question whether or not a claim which is a nullity falls within the scope of this rule.
Right.
32 to 35, the Supreme Court's considering a this court is considering a Supreme Court case, Roberts and Gill and Co. And that was an application by the claimant to alter the capacity in which he sued, and it was refused because a representative claim involved a new cause of action because the capacity in which the claimant made the claim was an essential part of the claim. Now, in the MNW skeleton, there is some criticism advanced of the court's reasoning in relation to this Supreme Court case because it said that the court in some way failed to appreciate that what was said by Lord Walker in the Supreme Court was concerned with assignments after proceedings have been commenced. We note that Lord Walker's dictum is expressly cited at paragraph 34 of this judgment, and it includes after proceedings have been commenced, so it's not clear to us how it could have been misunderstood. But importantly, what the court is doing here, if we look at the reasoning in 35, is that it's distinguishing the Supreme Court case. It's not relying on it, because it's saying it was concerned with introducing a new cause of action rather than regularising the pursuit of an already pleaded cause of action, which had been pursued by the wrong person. So we say it's really nothing to the point what Lord Walker was saying about assignments. The third case that is cited here, 36 to 37, is the Court of Appeal's judgment in Irwin and Lynch. And that's a case where the directors of a company entered into a contract with the company. The company then went into administration, and the administrator applied for a declaration that the contract was a transaction at an undervalue. The directors applied to strike out the claim against them on the grounds that the administrator had no standing to make the claim, and then the administrator applied to substitute the company instead. We see at 37, the Court of Appeal followed the earlier case of Parkinson Engineering that we've seen. This is Lord Justice Lloyd, paragraph 26. He says here the original claim was liable to be struck out, as it has indeed been because of lack of standing, but I see no good reason to regard the reason for the striking out as being a critical distinction. I would also reject the contention that the cause of action is not the same because of the identity of the claimant. Sometimes the identity of the party might be, indeed often might be, a vital distinction, but here Mr. Irwin plainly asserted the company's cause of action and asserted it on behalf of the company, just as the substituted liquidator did in the Parkinson Engineering case. So the cause of action is identical, it is already pursued for the benefit of the company, but it is doomed to failure because of the lack on Mr. Irwin's part of the necessary locus standi. it seems to me that it is possible and appropriate for the court to exercise its discretion under Rule 19.5 to allow the joinder of the company so as to accept the relevant claims.
I mean, sorry, I've been reading through as fast as I can with these, but isn't Parkinson and Irwin and Lynch, they turn on a specific provision of the insolvency legislation, don't they? Section 212, which is only a procedural section which allows a liquidator to bring a claim which is vested in the company. It's the company's claim and always ever has been. It's a procedural section only, which allows a liquidator to bring, on a summary basis, a cause of action vested in the company. And the problem in Parkinson appears to be that that was said to have been barred by a release. And Lord Justice Lloyd was making the point that it's the company's cause of action throughout. There's no question of it not having been a cause of action vested in a real person that still exists. And likewise in Irwin and Lynch. The administrator tried to use Section 212, which he can't, because he's not listed as person who's entitled to use Section 212. But it always ever was the company's claim that was sought to be vindicated. I'm not sure where these cases take us or the judge, frankly. But
Well, my lord, your lordship's quite right to say that's the context of those particular cases, but we do see at 38, he cites Mr. Justice Leggett, as he then was, his summary of the principles which he derives from those cases, and it's not in any way limited to those very particular circumstances. The principle he derives is that the court has power to order substitution under section 35(6)b and CPR rule 19.3.5b if 1. A claim made in the original action is not sustainable by or against the existing party, and 2. It is the same claim which will be carried on by or against the new party. So that, in my submission, is the correct encapsulation of the applicable principle that governs this rule.
But the point I'm making is that at all times, in both cases, there was a live entity which had a cause of action, and the dispute was really just over who was entitled to cause it to be vindicated. And we haven't got these cases. I don't think we've got these cases, but I think they must turn on the particular provisions of section 212, which is...
Your lordship may well be right that those cases do. In my submission, nevertheless, the summary of the principle by, as he then was, Mr. Justice Leggett, is correct. And we see, if we go over the page, that we then see this principle being applied in circumstances where AIG Europe Limited had ceased to exist. I'm looking paragraph 40 over the page at page 240. The objection, the argument that was put was, well, this rule cannot apply in this context.
AIG Europe Limited had ceased to exist.
My lord, yes. It was the named claimant.
Yes, but the cause of action transferred through the provisions of a cross-border merger under the regulation to AIG Europe SA.
AIG Europe SA was the assignee of the cause of action.
Well, it was the successor, universal legal successor, under a cross-border merger.
And the submission that was accepted in paragraph 40 is that the proceedings that had been commenced in the name of AIG Europe Limited were a nullity, because AIG Europe Limited had ceased to exist. So that is the scenario that the court is considering. Because AIG Europe had ceased to exist at the time the proceedings were commenced, the proceedings were a nullity. And so in my submission, the court is here considering the specific question which we are now faced, which is, does the principle, as encapsulated in paragraph 38, the principle that's derived by Mr. Justice Leggett in Insight, does that apply in circumstances where the proceedings are a nullity? And paragraph 41 rejects the argument that was made that it couldn't apply because the proceedings were a nullity. He rejects...
How does the judge get from 38 to 41? What's the reasoning process? I know he says that in 41, but how does he extract that from the authorities that he's been considering?
I'm sorry, my lord, I'm not sure I follow your question. How
Well,
does it extract
he states that 1953B is within, applies even where the proceedings would otherwise be a nullity. But the three cases that he's looked at in order to get there haven't said that.
My lord, they haven't. He is applying in my submission the test that is encapsulated at 38. So it's...
And he hasn't looked at any of the authorities about deceased natural persons.
My lord, that's fair. He hasn't. My submission about those is that they are pre-CPR authorities, and so the court is not bound by them. And the logic of the application of this rule to the situation where proceedings would otherwise be a nullity is in our submission entirely correct. We've seen that the Court of Appeal in Irwin and Lynch considered that one can correct the absence of a locus standi to bring a claim. That is what the Court of Appeal said was a legitimate use of this rule in Irwin and Lynch. And in our submission there is no principled distinction to be drawn between a person who is not able to bring a claim because they have no locus standi and the circumstances where the claim is otherwise a nullity. In both cases, the cause of action remains the same, which is one of the limbs of the principle to be applied. And the substitution of the party enables the cause of action to be pursued where it otherwise would not be. In our submission, there really is no principled reason to say that one could correct the absence of a locus standi to bring a claim and a nullity. So, how does this principle in 38 apply in the circumstances of the present case? We accept that the claims of deceased persons who fell within the class are a nullity, and so they cannot properly be carried on against the proposed or the defendants to the collective proceedings. However, if the personal representatives of the estates of deceased persons are substituted for the deceased persons themselves, then exactly the same claims can be pursued against the defendants.
Yep.
And so we say no changes are necessary to the allegations of breach of statutory duty, the allegations of causation, the allegations of loss. This falls clearly in our submission within the scope of this rule. It's not a different claim, it's the same claim being pursued. It can't be pursued if you don't substitute, but it can if you do. We say that this is squarely within the rationale of this rule.
In Mr. Terhal's case, a claim is made, put before the court, but it's put before the court by someone who doesn't exist. In this case, I think you have accepted that your class definition cannot be interpreted so as to include claims by people who were alive when they bought the car but died before proceedings were issued. I think you've accepted that. That's what the tribunal found, and I think you said you didn't challenge that.
Not quite. If we go back to what the tribunal found, there is a distinction between whether the claims fall within the class definition and the rejection of our argument that the class definition can be construed to encompass the estates, the representative of the estate. So
well, the class
171
consists of those who are defined by the class definition.
My lord, that's right.
You may have intended the class to go wider, but you define the class according to your class definition. The tribunal has said that does not include deceased persons, people who bought cars but died before proceedings began. And I think you told us that you don't challenge that. So if that's right, I mean, do correct me if I'm wrong, but if that's right, this is not a case where a claim has been brought by a deceased person and fails for want of standing. It's a case where no claim has been brought yet by a deceased person or their estate. So it's not quite the same as AIG, is it?
My lord, the tribunal has found that the claim... Can we look at exactly what they did say?
Yes.
It's starting at 171.
Yes.
The description of the class would extend to any person who acquired a new vehicle or a new leased vehicle during the relevant period, irrespective of whether that person has died.
Right.
And similarly, paragraph 175, towards the end of the page, on its terms, the class does encompass claims of deceased persons,
Right.
but insofar as it does, the proceedings are a nullity. What
Yes.
was rejected was our suggestion.
Yeah. All right. Yeah. Thank you very much. So they accept that it does include those people.
They accept that it includes those claims.
Yeah.
What they didn't accept is our approach, which was to say in those circumstances one can construe the class definition as including the estates,
Yeah.
the personal representatives of the estates of the deceased persons. So we are in a situation where the claims
Well
are
made.
within the class.
Yeah.
If substitution is permitted, those claims can be pursued. If substitution is not permitted, then they cannot be pursued. And in our submission, that falls very squarely within the principle articulated
Yeah.
in this rule.
So if you're right about that, then the CAT were wrong to say they had no jurisdiction. We would then have jurisdiction, and you would say, would you, that we should exercise our discretion or send it back to the CAT? to
My Lord, I
exercise?
would request this court to exercise
Yeah.
discretion. And if I may briefly make submissions on why we say that discretion should be exercised in our favour. 3 points. As I've submitted, in contrast to merits, it was always the intention that claims on behalf of deceased persons be included. The collective proceedings regime is a nascent and developing regime, and prior to the ruling of the CAT in the merits remittal case, it wasn't clear that the way to encompass the claims of deceased persons and estates within the collective proceedings was expressly to include their class representatives within the class definition. And in our submission, it would be unfortunate if that lack of clarity led to an inability to pursue those claims. And we do say that that would be an outcome which would frustrate the purpose of the collective regime, which, as the court has emphasised, is to facilitate the vindication rather than the impeding of rights.
What's the current practice? I mean, obviously, there's a certain amount of archaeology here. This is, people have woken up to this issue or this glitch. So do people now define the class as the individuals, or if deceased, the personal representatives thereof?
Words to that effect, yes.
Yeah.
It's now become recognised that that is the way to do it, but of course that was not evident at the time.
And that's since Merrick's remittal.
That's since merits remittal, yes. So we do ask this court, if it is with us on the point of principle, to exercise the discretion in our favour.
And is it fair to say, as a matter of practice, that's the commonplace now, post-Merrick's?
That's certainly my understanding, and those
imagine
behind me
it's
seem to
a-
agree with that, yes.
Nods all round.
I'm grateful.
Yes, Mr. Fisherman.
My Lords, I should start by saying I hope that there's no objection to me addressing the court from here. It's just that with
You're easier to hear in front.
with the
row,
microphone. Yes. So with your permission, I'd like to start by summarising what we say about the cross-appeal. And I'd like to do that by reference to what the rule actually says. So if we could just turn that back up. In fact, turn it up for the first time, I think. In the authorities bundle, it's at tab 29 of the authorities bundle.
Do you want more than is quoted in the CAT judgment?
It is, that's right. I've got the whole.
Or do you want more than that, do you?
I've got the whole rule so you can see it all in context. I'm not going to go through every word, but just so you can see the broader picture. It's page 912.
Right. Yes.
So the whole rule is headed additional parties, and Ms. Ford rightly said that the relevant rule, bit of the rule for our purposes, is paragraph 6. The only additional contextual point I just wanted to make, and I apologise if this is obvious, is why we're looking at paragraph 6. and not some of the earlier paragraphs, like paragraph 4. And the reason for that is that the class representative in this case waited until the very last day of the limitation period to issue these proceedings. And so by the time the class representative decided to apply to add the personal representatives in the estates to the claim, it was too late to rely on paragraph 4a that you can see here in the rule.
Yeah.
So, as I'm sure your lordships know, you can't just add parties after a limitation period has expired because it's desirable to do so. But the rules pay proper heed to the significance of an accrued limitation defence. That's actually what's at stake here. Now, as you've seen, paragraph 6 does that. It pays due heed to the significance of our limitation defence by saying that you can only do this, add or substitute a party, if the additional substitution is necessary in the particular ways that are particularised. And it's only limb B that is at issue here. And just to make concrete again, just so there's no confusion about the way that I understand my learned friend's case on jurisdiction, on how this applies, they say that the claim form as originally pleaded should be read as having purported to bring claims on behalf of deceased persons themselves, so the dead people. That the claims were brought on behalf of those people that were in the class. So the original party, I think it's actually common ground that there needs to be an original party. I mean, it's there expressed in the rule. The original party is a deceased person. And then they say, oh, well, we can't properly carry on a claim by a deceased person because a claim in the name of a deceased person is a nullity, and that much is common ground. And so that's why they say they need to make a substitution here. They need to take out the deceased person, and they need to put in instead the living personal representative of the estate. And you've seen that in the drafting of the proposed class definition. And so that's how they seek to bring themselves within the scope of the rule. And then they ask you to exercise your discretion. And just to summarize the 3 different levels at which we oppose the cross appeal, our first point is we say you don't get off the ground here. We don't need to get into the case law on deceased persons, because properly construed, the claim form did not purport to bring claims on behalf of the deceased persons themselves. And that is a cross-respondent's notice point. So that's contrary to what you saw in paragraph 171 of the judgment. The second point is, if I'm wrong about that, we say that even if the claim form had purported to include deceased persons, then they can't rely on this rule where the original party was a deceased person, because that claim, indeed that person, is a nullity. It's nothing.
So your short point here is if the purported claim is a nullity, it's not a claim.
That's right. That's right. Or there's no original party, to use the wording of the rule. And that's the reason that the tribunal gave in paragraph 181, which again you've seen. And then finally, if they can rely on the rule, then we say the court ought not to exercise its discretion to allow them to do so. So those are my 3 points, and most of the time I think will be spent on the second point. But if I could just quickly begin with the first point, which is about the interpretation of the claim form. And so for this we need the original claim form, which is in the supplemental bundle. I know you've seen it more than once. But tab 1, page 14.
You say the original. This is the amended one.
That's right, but amended before the CPO hearing.
Yeah.
Yes.
So we're looking at the definition on page 14.
That's right, paragraph 42. So they say that the proposed class includes all persons who, during the period 2006 to 2015, either purchased or financed in the United Kingdom a new vehicle or a new lease vehicle. And then immediately below that, you can see there's a definition for the word persons, which is defined to include all persons, whether legal or natural. And we say that gives rise to a question of interpretation. And the question of interpretation is this: does all persons in this document mean any entity, if I can just use a neutral word, any entity that has ever been a person, even if it's not a person at the date of this document? So that's my learned friend's interpretation. Or does the term all persons mean, and is it limited to, any entity that is a person at the date of this document? And my lords, one point on which I agree with my learned friend about this whole topic of interpretation is that context is everything. And just to give an analogy for what I mean by that, interpreting words like this, all people. Suppose you went to a wedding at a nice village church somewhere, and an usher said at the beginning of the proceedings, "Please could all friends and family of the bride sit on the left, and please could all friends and family of the groom sit on the right." I don't think that anyone would be under any doubt about what is meant there. What's meant there is all living friends and family of the bride who are here at church today, could they please sit on the left? Nobody would interpret that to mean the ancestors of the bride that might be buried just outside in the churchyard. And we know that. It's not a difficult question of interpretation, because we all know that only the living are invited to sit anywhere in a church during a wedding. And we say that collective proceedings have one important feature in common with weddings, which is that only the living are invited. And that much, you've seen, I think, today, has always been common ground in these proceedings. My learned friend accepts that. But perhaps I can just show you why, very briefly, by reference to the statute, about what collective proceedings.
Just before we move on, then the dispute between you as a matter of construction is whether it's all persons alive as of the date of the claim, or all persons alive as of the date of the purchase or finance.
Exactly. Your Lordship gets it exactly right. And we say when you're answering that question, we need to bear in mind what these proceedings are. And to answer that, we need to look at the Competition Act and its authorities, tab 28. Page 905. Section 47B1, which tells us what a collective proceeding is. It's a proceeding that combines two or more individual claims. So the only entities that can ever be included in a class are entities, again to keep using that word neutrally, that are capable of being claimants in their own right. And everybody knows, and Ms. Ford has accepted, that the dead cannot be claimants. And we'll see that again when we come to the cases shortly. But as I say, it's common ground. And so we say that the function of a class definition, which you need to understand before you interpret it, is to delineate, of all the entities in the world who could conceivably be included within the class, which ones are in and which ones are out.
Claim relates to a course of action. Doesn't that accrue when you purchase the vehicle? That's when there's a breach directed at you, which later becomes subject to a claim.
That's quite right, but that person is not a person who could be included within a class. It's not a person who could bring a claim on the date of the claim form.
So your focus is not on the breach or the course of action, it's upon the mechanics of the claim.
Because what we're interpreting here is a part of the claim form that is telling you which person's claims are being combined, to use the language of section 50.
This was the reasoning in the Merrick's case, wasn't it? That you couldn't have brought a claim under 47A.
That's right.
Therefore, you can't be part of the class under 47B.
And that's common ground. That much is common ground. What I'm adding here is that when we interpret the words in the claim form, if there's a choice between two different interpretations that's open on the text, that haven't expressly said, including people who are now deceased as of the date of this claim form, that's not our case.
If you're right, it undermines Ms. Ford's analysis only to the extent that she relies upon intention or construction.
Well, subjective intention is obviously irrelevant. We're construing the words in their context, and their context is section 47b(1). So we say if there are two interpretations of the words that are open on the text, and we say they're clearly open, then you should choose the one that is consistent with the function of a class definition.
Yeah, I mean, it's a well-recognised principle. You choose something which produces a valid result over something which produces an invalid.
Exactly. We say it would take something quite extraordinary to interpret, and very direct, to make you interpret a class definition as including people that everyone knows can't possibly be within a class. But the problems of interpretation go further, my lords. This is an opt-out claim. And one feature of opt-out claims is that every class member who is domiciled in the UK at the domicile date, and that's the 20th of May 2022, and does not opt out, is in the claim. And just to give the reference, that's section 47b(11), which is actually on the next page. We don't need to look at it, but that's the way it works. Everyone who's in the class, everyone who meets the class definition and is domiciled in the UK will then automatically be a represented person if they don't opt out. And for that reason, it's obviously very important that the class representative has a plan to notify all class members about the claim and update them on progress. And for your note, that's Rule 78(3)(c), which you can find in paragraph 28 of the judgment for Bundle 11-148. And actually, you saw before, Ms. Ford took you to it, the section of the litigation plan in which they talked about how they were going to communicate with the class members. And so if you read the claim form in the way that Ms. Ford wants you to read it, which is that it actually includes deceased persons, they're in there, then how exactly is that supposed to work? You know, what did the class representative think it meant? Or what would an objective reader of the text think it meant for a deceased person to be domiciled in the UK in 2022? What plan did the class representative have to notify deceased persons about the claim? Now, how did anyone think that deceased persons themselves were going to exercise their right to opt out of this claim and say, not in my name? There's no answer to any of those almost metaphysical questions, really, anywhere in the class representative's application for certification, at which time we're told they intended these entities all to be included. And nor is there any explanation of that now. So in that context, we say it would actually be most unnatural, and I say that in every sense of the word, to read the reference to persons in the claim form to include a reference to deceased persons. And the only other point on this topic that I need to deal with is my learned friend's point that, well, they're quantum estimates, which are very broad brush and didn't take account of a lot of exclusions, really. Those all included people, whether they'd purchases that happened during the claim period, whether the person who made that purchase was still a person at the date of the claim form.
Do we even now have any idea how many people this might affect? I mean, how many estates they want to bring into the claim? Do we know?
I understand the question, and the short answer is no. The slightly longer answer is that the class representative had to put forward a methodology for dealing with that. And they did that in submissions after the certification hearing, after judgment, if I recall correctly. That's dealt with in the PTA ruling from below, and we don't have any argument about it. So it's common ground that there's a way to do it.
Yeah.
But I don't know what the answer is. So, my lords, we say that's the first reason why this cross-appeal should fail. But my second reason is in some ways even better, and that is that even if the original party, even if there was an original party, a null original party, in the sense that, suppose the claim form had expressly said, including deceased persons, so they're definitely in there, still, Rule 38, 7b is not engaged, and that's because as we saw earlier, and I think is still common ground, the rule expressly requires there to have been an original party. And so the question of interpretation of that rule that arises on this cross-appeal, and that was considered in the AIG case that you saw earlier, we say wrongly, but the question of interpretation is this. Is it enough that the claim form, or the class definition, has some sort of text on it, in the bit of the form where the name of the claimant or class member should be? Is that enough? Even if that text in question is actually legal nonsense and does not actually refer to any real person. Or, that's my learned friend's interpretation of the rule, and that seems to have been the interpretation of the deputy judge in AIG. Or alternatively, does the original claim actually have to contain the name of a real person or a description of a class of real people who actually exist at the date of the claim form? Which of those two things is required for there to be an original party? And we say that the natural meaning of the words original party, particularly the word party, is a real person who is actually capable of being a party to the litigation. Or in this case, a real person who is actually capable of being a member of the class. That's just the natural reading of the text. But we say it's also supported by more than a century of case law. And although the procedural rules concerning the addition and substitution of parties that were addressed in those cases have changed over time, there has always been a requirement that there should be an original party. And through successive enactments and successive versions of the rules of procedure, that requirement has consistently been interpreted to mean that the original party must be a real live person. Now, I'm not going to bore you with the whole set of those authorities. And I think it's enough that I take you to one, because...
When you said original party, you mean as of the date of the claim?
That's right, yes. That's right, it's okay if they died later, because then there wasn't.
Because they weren't a nullity when the claim was issued.
And of course...
there was something as of the date of the claim to be handed over to the personal representative.
That's right, and if your lordship had in mind the possibility that there might have been an original party before the claim was issued, well, that's impossible on the wording, because you can't be a party to proceedings that don't exist. That's why I say party is a significant word, just as a matter of construction. The authority I'd like to go to is Dawson and Dove, which is a 1970 decision, I think. And it's tab 3 of the authorities bundle, which I imagine is the first one. Just while you're getting that out, in this case, it's different from our case. It was actually the defendant who had died before the proceedings, about 18 months before the rules were issued in that case. And I'll just wait for you to get it. He had been, the defendant, the deceased, had been the landlord of a building in which the plaintiffs were tenants, and water had escaped from his bit of the building and caused damage to theirs, and they sued in negligence. And if we just go to page 11, we can see the bits that I want to refer to. And the judge begins at the top of the page by setting out the relevant rules that applied in that case. And we just need to keep a bit of a grip on which set of rules he's talking about, because he goes through the older cases as well. The rules he's talking about are the 1965 rules of the RSC, the Supreme Court. And the most relevant one for our purposes is set out just in the last few lines of that first paragraph, which is Order 15, Rule 6. And in particular, the bit that says that at any stage of the proceedings, the court may order any person who has been improperly or unnecessarily made a party to cease to be one, and to order that any person who ought to have been joined as a party to be added as well. And then, if we can just pick it up at the letter E, you can see that the judge refers to two earlier cases that have been cited to him on the meaning of the 1965 rules. Those two earlier cases were Clay and Oxford, and then Tetlow and Orella. And obviously those weren't decided under the 1965 rules. They were under two separate earlier sets of rules. And both of those were cases like our one, where it was the plaintiff who had died before the writ was issued. Now, Clay was decided under the old Common Law Procedure Act of 1852, and it was decided by the old Court of Exchequer. And the only reason I say that, and your lordships probably know, I didn't, but that was actually an appellate court. It's shortly before this court was created, I think a couple of decades later. So it's not a first instance decision, that one. And if we just go down to the letter H, just draw attention to what Baron Bramwell said in that case, in the Clay case, said that the powers of amendment conferred by the statute did not apply to a case where there was no plaintiff, and therefore no existing suit, and no question in controversy between parties. And the judges put parties in inverted commas in much the same way that I have. And then over the page, we can see reference to the second case, Tetlow case. That's an amazing case where the plaintiff, didn't laugh, but the plaintiff actually died 8 years before the writ was issued. And it was a claim for passing off in relation to some toilet powder. And that was decided by under the 1883 RSC. And the argument was made, we actually have it in the bundle if anyone's interested afterwards, but the argument was made that the 1883 RSC were different from the old CLPA, and so a different result should obtain. And the Red Book, which is what the White Book used to be, said that was right. But the judge said it was wrong. You can see the indented text at the letter B, that Mr. Justice Russell in that case thought that the outcome should actually be the same as it is with the CLPA. And so the new rules at that time, the 1883 rules, supported the same conclusion as the previous rules, essentially for the same reason. And then in the bottom paragraph on this page, you can see what the judge in this case, in Dawson, is saying, it's Justice McKenna, is that the language of the old rule, the 1883 rules, didn't distinguish between plaintiffs and defendants, next to the letter H. And so under the old 1883 rules, it's clear that the fact that you sued a dead defendant was incurable. The reason why I draw attention to that will become clear shortly. Over the page at letter B, you can see his reason continues. He says that the 1965 rules are effectively the same as the 1883 rules, and so the result should be the same yet again. And then I go down to the letter G. At the letter G, we can see reference to a Law Commission white paper about proceedings against estates.
Yeah, and that's been changed and it goes into the CPR, but it doesn't apply to claimants.
Yes, your Lordship has cut short my submissions on this point. That's exactly it. Yeah. We say, since it's the same principle, and you can actually see over the page that the white paper actually cites Tetlow. So they knew very well that the position was the same for plaintiffs. It's actually, they were inferring what the position should be for defendants. And so we say that it would be remarkable, really, if you were to interpret the rules now differently for plaintiffs, for claimants, for class members, from what they were before. The modern rule is about defendants is 19.8, CPR 19.83. I don't think we need to turn it up, but it is in the bundles, page Authors 27.902. So the point is that the drafters of the rules fixed the problem that the plaintiffs faced in Dove, but they didn't fix the problems that the plaintiffs faced in Clay or in Tetlow, and that's the same problem that my learned friend has today, and it's not been fixed. That's one of the points I make from this history. It's not the only point I make from this history, though, because I also say that the principles stated in these older cases, these same principles continue to be applied in modern CPR authorities. And I just need to qualify that slightly, because other than this case, and also other than AIG, which I'm going to come to, I haven't found any examples of any cases in which anyone has been so audacious as to try to rely on the addition/substitution rules in the CPR to substitute for a deceased plaintiff. I say audacious because it is audacious to do that in the face of the authorities that I've shown you and the point of construction based on 19.8.
Well, the Milburn-Snell case, which we've got in our bundle, says once a nullity, always a nullity.
Well, that's right. That's,
rescue it.
that was where I was going next.
Yeah.
But perhaps I don't really need to turn it up because it really does say exactly what your lordship has just put to me. I mean, perhaps then I was going to hand up Kimathi, which is another case.
That was the one referred to in Merrick's case.
Goodness, yeah. Yes, it was. And in paragraph 5 of it, it cites Clay and it cites Tetlow. The only other point I was going to make about it, my learned friends have a copy. The only other point I was going to make on it is that it's not just authority for the proposition stated in Merrick, which is that it's a nullity. It's also authority for the proposition that if you ask the court, because the claimants did, that they asked the court to exercise its general case management powers under CPR 3 to just do the just thing and cure the defect and carry on. And the court said, no, you can't. And it said, no, you can't for 2 reasons. One was because of the proposition in Milburn-Snell that your lordship has just rightly put to me. And the other one is because of the historical authorities, which are cited in paragraph 5, which are the same ones that we've been looking at. And that's why I say those principles are living, breathing principles of the CPR as well. So, my lords, I think unless... Oh, sorry, I do need to address your lordships on AIG, but I think, given that you've seen it, I probably don't need to say very much about it, which is just, my only point about it really is that the learned deputy judge didn't have cited to him, he wasn't helped by having the wealth of authority that we've just discussed. And beyond that, the only thing I would add is that its effect, I don't mean to be rude, but the relevant point, the point that's relevant to us, is effectively not reasoned. He states his conclusion, doesn't follow from the authorities that is discussed. And then the missing bit that, to be fair to him, he didn't know, is that it's contrary to loads of authority.
Did Mr. Justice Leggett cite these authorities in the authority that is cited in paragraph 38?
So Mr. Justice Leggett's case, the Insight case, is not in the bundles. It is also not a case in which there's a deceased person or a nullity. I'll be corrected if I'm wrong, but I believe it's, I'm sure it would have been cited if I was wrong about that, but I believe it's not a case in which there was a nullity. So it just doesn't deal with this issue. As I say, as far as I know, no one has ever been audacious enough to try this on.
Neither is Insight or Parkinson.
Sorry?
Neither was Parkinson or Irwin and Lynch.
Quite right, my lord. Yes. All I was going to say about those was precisely the point that your lordship has just made. Yes. They don't discuss the point, they don't analyse it, they don't decide it. Certainly not against me.
Yeah.
So those are my submissions on the second topic, which is that there's no jurisdiction here.
Yep.
That takes us to the third topic.
When you say no jurisdiction, we're not within Rule 38.
Sorry, that's what I mean. Sorry, that's probably a pompous way of putting it.
No, I'm just translating from my note. Not within Rule 38.
That's right. And that's even if the original claim form had said it clear as day includes deceased persons. So on discretion, I think I can be quite short. The key points are these. If you get to the stage of discretion, it's because the class representative has made a very basic and entirely unforced error. And I don't mean that rudely, everyone makes errors. But that's what's happened. It's clear as day, there's not even any dispute about the fact that it was wrong. So that's how we got here. It's also clear that they knew all the facts that they needed to know in order to plead the claim properly, in other words, including the personal representatives, but they failed to do so. My learned friend faintly argues that, oh, well, until Merrick's, nobody really knew. But that's really not right. I mean, Kimathi is another group litigation claim, as your lordship knows. It was a GLO. And we've looked at Section 47B of the Act, which tells us what a collective proceeding is. And it says it's just a combination of individual claims. So I don't understand what it is said that a person wouldn't have understood if they'd actually thought about it. The limitation period, that's the second point. Third point is the limitation period is now expired. And so we have an accrued limitation defense to these claims. So the question is, why should the court come to the aid of the class representative and deprive the defendants of their limitation defense? And one answer that you might be tempted to give is that the class representative's error is not the fault of the people who are affected, people who are affected by it one way or the other. But we say it's telling in this case that the class representative has not put forward any kind of a plan or any kind of account of a plan for getting the proceeds of any damages that are awarded in this case to the beneficiaries of the estates of the people who died before 2020 when this claim was issued. We say it's really implausible that any material sums would be distributed to the beneficiaries of those estates. As you've seen, the sums...
Isn't that the same for almost all claimants? Doesn't it? I mean, I understand the point, but
well,
we're dealing with the point of distribution, which is essentially something which is parked a long way down the line.
That's right, my lord. I'm dealing with maybe I don't need to, a counter-argument which says, well, it's not these guys, the people who made the error aren't the people who suffer the consequences. But what I'm saying is that actually they are, because this money we're talking about, the estates money, we're talking about estates that will all have been wrapped up.
Yeah, I was just about to say, I mean, is it right that if you're the personal representative of somebody who has died, but who had an accrued cause of action, you can bring proceedings if as personal representatives on behalf of the estate?
But subject to limitation.
Yes,
Yes.
subject to limitation.
Yes.
So if somebody has died, what this should have done, I think you say, it should have said people who are alive as of the date of this claim, plus the personal representatives of people who bought but have died.
That's right.
But your point that you've now just made is that would have required them to think about, well, how if an estate has actually been wound up, fully wound up,
Yes.
and the personal representatives, the executors, are not acting anymore,
Yes.
how do you deal with that situation, even if you notionally include them as a matter of drafting in the plan?
And my submission, my lord, if I was at first instance and someone actually put before me a claim form that purported to do that right from the off, I'd be making interesting submissions about that, about whether it's really right that they should be included. But that's not this case.
Yeah.
This case, we're dealing with a different point, which is, should we help the class rep and the funder and the lawyers out by making this amendment now?
Yes, but I thought the point you were making was, if they had done it properly, it would have it would give rise to a whole host of other
Practical
issues.
That's right. But the additional point that I'm making is that really what this is all about is the aggregate award of damages at the end of the day being larger. And where's that going to go? Well, I think the point of it is that it goes into the pockets of the lawyers and the funders. Because it's not going to go to these estates. It's just entirely unrealistic.
That depends upon the extent to which the CAT supervises costs, and of course the distribution is either to the class or to the nominated charity. And I think the point which I hadn't quite appreciated was that a lot of these estates will have been wound up. The personal representatives will have disappeared, and that is a distinction between categories of people prior to the claim and people after the claim.
Yes.
Who will have been subject to some form of notification procedure by the representative, class representatives.
Yes.
And they can then take into account the possibility of a recovery, however small or modest.
That's right. Your Lordship has put it much better than I had. So we say, then just finally, turning to the points that Milena Fred made about discretion, we say that none of them help her. She says that it was always intended. That's nice, but it doesn't get them home because, in fact, if it's true, I haven't seen any evidence, but if it's true that it was subjectively intended, they actually thought about it, then really that makes it worse because having thought about it, they really should have got it right. In any event,
you've got a period here which begins in 2006, ends in 2015, and you don't start the claim till 2020.
Yes.
It would be obvious that some people will have died between 2006 and 2020.
Yes, Melody, exactly. The second point I've already dealt with, which is that the regime is nascent. It is nascent, but it's not nascent in any way that is relevant. And then the third point is that that if you refuse permission, that will frustrate the purpose of the Act. But that was the relevance of the point I was making earlier, that if the purpose of the Act is to facilitate compensation for real people who have suffered loss.
Yeah.
That's not something that's happening here at all.
On the other hand, we only get to this stage if we're satisfied that the claim cannot properly be carried on
Yes.
without the party. So we would say, well, we're satisfied that the claim can't properly be carried on without the estates being added, but we're still not going to do it.
That's right. But the reason for that is that the claim that was articulated is a nullity, and that's what centuries.
No, nullity is a different point. Nullity says, well, there's no claim that you can rescue. That's
Well, my lord, the first two of my points.
It was born dead and cannot be revived, I think is what Lord Justice Scott says in one of the cases that's quoted.
That's Melbourne Snell, yes.
So that's your point too.
Yes.
But if we come to the view that
I see. I'm sorry, my lord.
it's only in suspended animation and it can be revived,
yes.
and we're satisfied that the claim cannot properly be carried on
yes.
without the amendment, you still say that we should reject, as a matter of discretion, the amendment, even though it means that a proper claim cannot be pursued.
A proper claim for those.
Yes.
Yes, that's right, and that's because we have a limitation defence.
Yeah.
And so you need a good reason to take it away from us.
Yeah.
And there just isn't one.
Well, limitation doesn't normally correct errors
My lord, sorry?
on the part of lawyers who forget to do something in a document. It's a fairly strict and unforgiving doctrine.
My lord, that's exactly right. And this is an exception to what is, as you say, a fairly strict rule. And you need good reasons in order to overcome it, and there just aren't any.
Yeah.
So, my lord, unless your lordships have any questions, that's it.
Thank you. Mr. Singler, do you want to add anything on this?
Well, nothing to add. We adopt those submissions entirely.
Right. Yes, Ms. Ford.
And those very brief points in reply. On the first point concerning the interpretation of the claim form, we gratefully adopt Lord Justice Green's articulation of the issue between us, whether you interpret the claim form as all persons alive as at the date of the claim, or all persons alive as at the date of the purchase or finance of the vehicle. Our submission is that in the true construction of the class definition of the claim form, it is clearly persons alive at the date of the purchase or finance of the vehicle. And we say that's true because the key concept which is driving the class definition is the act of purchasing or financing a vehicle. So it makes sense for all persons alive at that date to fall within the claim. We also gratefully adopt the point that Lord Justice Green made, that the cause of action accrues at that time as well. And so that is another reason why that is the time which makes sense. My Lord Justice Lewison made the point that one seeks to choose a valid result over an invalid result, but of course that construction does give a valid result as at the time, as at the relevant time of the construction of the claim form, as at the time of the purchase of the vehicle. It is only that the happenstance that the class member has subsequently died that causes that interpretation to lose.
I think the point is a slightly different one. Mr. Pidgeon says, no doubt correctly, the purpose of the class definition is to define those who are bringing the claim in the claim form. If the class definition is interpreted to include to include entities, to use his word, who are incapable of bringing a claim at the date of the claim form, because they are dead, then that produces at least a partially invalid result in terms of defining a class. And it was in that context that I suggested that, well, there is a principle that you prefer a valid outcome to an invalid outcome. I entirely accept that if you're simply looking as at the date of the purchase, then why should you not include anybody who was alive at the time? And that may well be so if all you were doing was trying to capture people who bought cars. But his point is, no, you're not just doing that. You're trying to capture the people who are bringing a claim.
I certainly see the force of the point, but in our submission, what's doing the work in the class definition at the core of the claim is the act of purchasing the car. And so we do say that that's what you focus on when you ask, well, is that person alive at the time? So we do say that the CAT was right for the reasons that it found at 171 and 175. The second point concerned the construction of the relevant rule, and the point was made that the rule includes the concept of an original party, and it was said that an original party must mean a party who is actually capable of bringing litigation. In our submission, that is not consistent with what the Court of Appeal said in Irwin and Lynch. Irwin and Lynch was the case where the original party had no locus standi to bring the litigation, so by definition it could not be an original party in the sense defined by Mr. Pitchinen. And in our submission, when one applies the summary of the applicable principles in articulated by Mr. Justice Leggett, it's very clear that that concept is sensibly able to accommodate circumstances in which the underlying claim is a nullity, and there's no sensible distinction between the Court of Appeal's reasoning in Irwin and Lynch, where there's no locus standi, and a claim where the claim itself is a nullity.
So you would say that not only are the CAT wrong in this case, they were wrong in Merrick's.
I do not think this point was raised and argued in Merrick.
I thought it was. I thought that's where the CAT got it all from.
I'm grateful that the clarification behind, they certainly made the finding that a claim is a nullity, and we don't contest that. What was not argued before them was the point we make on the basis of AIG.
Oh, I see. So even if it's a nullity, it can be rescued.
Right.
Right.
Reliance is obviously placed on pre-CPR authority and on Milburn and Snell. It's common ground that the pre-CPR authority concerned different rules and so isn't binding on this court. And in our submission, the reasoning in Irwin and Lynch, which concerned these rules, is the more immediate focus for these purposes. Similarly, Milburn and Snell, different rules. It was 19.8 rather than these rules. We say it's perfectly legitimate to apply the authorities that have construed the rules we are particularly concerned with here, and they are capable of accommodating a claim which is a nullity. Finally, the court has my submissions on discretion. I do address very briefly the point that the effect would be to deprive the defendants of a limitation defence, and I simply make this point, that the claims as they originally included, as the CAT found in 171 were originally included, there was no limitation defence to those claims at that point. A limitation defence arises because of the happenstance that the persons who had a valid claim passed away. And in our submission, it is not an attractive submission that the court should exercise its jurisdiction or its discretion in such a way as to ensure a limitation defence which arises due to the happenstance that the original claimant is deceased, and thereby to deprive the estates of the claim that would otherwise have been pursued. And unless I can assist further those of our submissions.
Would it follow that if a personal representative had brought an individual, not collective action, a year after the deceased, that would have been a nullity?
I think there might be limitation obstacles to that, in the sense that we brought our claim just within the limitation period.
But assume someone a few years earlier.
That, yes.
Because as of the date of the claim, the deceased would be deceased and a nullity. So the personal representative couldn't have brought a claim, let us say, in 2017 or 2018, well within limitation.
They could have done, but of course, the very point of the collective proceedings in this context is essentially the recognition that this is a mechanism to enable claims to be brought that really wouldn't otherwise be brought. The reality that underpins
it's a different justification. It's a question of pragmatism and practicality. Very small claims, very large multinational defendants never going to happen unless done collectively.
My lord, yes. And so in my submission, it's not realistic to make the point that the representative of the estate could have brought a claim in time, because in the context of collective proceedings, the whole regime...
Maybe I'm being a bit silly. Maybe I'm just forgetting the basics. If the purchaser dies, 2 years later, the personal representative wishes to bring an action, individual action, for 50 quid, what have you, can they do so?
Yes.
I believe they could
Yeah.
act on behalf of the estate in order to pursue that claim, yes,
If within limitation.
if within limitation and subject to the realities of the matter, that this regime is here precisely because such individual claims would not
Just
in
wouldn't
reality
happen.
be pursued. My lords, those
Thank
are my
you.
submissions unless I can insist further.
No. Thank you very much, Ms. Ford. Won't surprise you to learn that we shall reserve our judgments. You will get a draft in the usual way. It will be your opportunity to correct our spelling and our grammar, but not our reasoning, and not to raise new points. The draft judgment will come with a very fierce embargo. It means what it says, and breach of the embargo may be treated as a contempt of court. The judgment can only be distributed to those people whose email addresses have been notified to the court before the appeal began, and it will be the responsibility of the solicitors to distribute the draft to those people who are entitled to see it and to nobody else. In the light of the draft, we hope that you will be able to agree a formal order. If you can't agree a form of order, please make short submissions in writing, and we will make the form of order that we consider to be appropriate. Thank you all very much for your arguments.